Greetings, colleagues and enthusiasts of corporate law channel. My name is Matthew Zokoth, and I take this chance to sincerely welcome you to this program. This is episode 8 of this program, through which I serialize some of the contemporary corporate issues that arise in Kenya with a view to giving them legal flavor. Now, in this episode 8, I will discuss a form of loan finance called overdrafts. Overdraft facilities are common, I believe. Many of us have heard of them, but it's important that we understand some of the legal mechanics that arise from these kind of facilities. Now, overdrafts are part of a broader category of loan financing. There are other forms of loan financing which we will not be discussing in this episode, but it's important that we highlight them. One of them is what is called bilateral term loans. As the name suggests, bilateral term loans involve two parties, one lender, one borrower. But the key characteristics of a bilateral term loan is that it is for a specified tenure, predetermined tenure. So as long as the period of extending the facility subsists, the lender will be obligated to continue extending the facility to the borrower, of course, unless there is a material breach in the terms of the lending. Now, there is another form of loan finance called syndicated loans. At times, some facilities may be so large that not one lender can take up the risk of extending the facility, or they may not even be in a position to extend, even if they were willing to take the risk. So they may come together as a group of lenders and extend the facility to a single borrower. Now, that kind of facility is called a syndicated loan. And just like a bilateral loan, is a form of a term loan, meaning it exists for a specific tenure, say 5 years, 7 years, 10 years, 25 years, some even extend up to 30 years. So as long as the period of lending is not expired, the lender will be enjoined to extend the facility to the borrower. Now, there is another form of loan financing called a revolving loan, which is also a kind of a term loan. And this is a type of loan that allows the borrower to, reborrow, pay, reborrow within, of course, again, within a specified period. If, for instance, that revolving loan facility exists for 5 years, then within that 5-year period, the borrower will be entitled to borrow the facility, the approved facility, pay the facility, and again reborrow. It's kind of a revolving facility in nature, right? Critically, it is a term loan, meaning it subsists for the period that is pre-agreed upon between the borrower and the lender. Then the last form of loan finance, which is a more advanced form of loan finance, is called securitization financing. Like I said, we won't go into detail about some of the legal mechanics about these forms of loan finance. We'll get a chance to discuss them. But the key characteristic of securitization financing is the kind of first is a term loan, is also a term loan, but is advanced on the security of an underlying portfolio of assets. So if, for instance, the borrower has a chain of businesses, they can identify an aspect of their business that is profitable, and then that aspect of the business secures the financing. In Kenya, this kind of borrowing is commonly known as asset-backed kind of facilities, as called asset-backed securities. It's just securitization, it's the same thing, really. Asset-backed meaning that underlying the facility itself, there is a portfolio of assets that secure the lending, from which whose performance will then repay, the lending that is extended to the borrower. Securitization financing is most common with listed companies. Actually, it's only listed companies that can undertake this kind of financing. But for today, we'll discuss overdraft facilities as a form of loan financing. So overdraft facilities are linked to the operation of an account of a bank customer, and what it does is that it enables the bank customer to operate an account to a point that that account is overdrawn to the negative, right? So it is a kind of facility that allows a bank customer to draw its account beyond the credit that is standing on the account at any given particular time. This type of financing is actually, loan financing is actually typical to help in the working capital of a company. As we may know, most companies, there's always a time lag in most companies from the time that they generate assets, sell these assets, and get paid for them. For instance, take a company that, which example can we give? Take an example of a company that deals in furniture, right? Now, from the time that this particular company makes the furniture, markets the furniture, and then actually sells and gets paid for it, okay, it takes time. All right, but in the intervening period, there could be certain financial needs by this particular company. The recurrent expenditures, be it employee salaries, be it taxes that are perhaps due, or other capital, working capital needs like the cost of acquisition of raw materials. So the overdraft facility then comes in handy to fill that liquidity mismatch between the time that the company generates assets and the time that it actually is paid for those particular assets, so that the company can continue to operate uninterrupted, right? Now, this is not a type of finance that is to be used to invest long-term by the company. A company cannot rely on overdraft facilities to undertake a takeover bid. Why? Because in a takeover bid, there is this acquired company, there need to be synergies that are put together so that it is turned around and to return to profitability. All right. So that period may be long, beyond the permitted period typically in an overdraft facility, right? It's not a type of financing that a company can opt for long-term investments by the company. If the company needs such kind of financing, then it has options. Can either go for bilateral financing, or it can only, if the financial needs by the borrower are large enough that cannot be facilitated by one bank, it can actually identify one underwriter to put together a syndicate of banks to lend the money to the company, right? So overdraft facility is a type of loan finance that is typically used to help the company sustain its working capital needs. Now, for it to be valid, and there needs to be an agreement between the bank. Generally, there needs to be an agreement between the bank and the borrower on the limit of the overdraft facility. Okay, so there will always be not so extensive, and we'll understand shortly why most of the overdraft facility contracts are never very extensive contracts, right? But the bottom line is there needs to be an agreement between the borrower and the bank on the extent of the overdraft itself. the extent to which the bank customer can overdraw their accounts. There is no automatic right to a bank customer to an overdraft facility. Generally, there must be an agreement to that effect. All right? Now, if there is no agreement between a bank and a bank customer for an overdraft facility, and the bank, either by mistake or deliberately, honors, say, a check that is overdrawn, still, courts have held that the customer, by drawing, a check that is in excess of the amount standing to the credit of the account at any given time, will be seeking a loan from the bank. And if the bank honors that check, then an overdraft facility will have been created, right? And so the bank will be entitled to demand repayment of this facility based on its usual terms and usage. So as a lawyer, I think it will be an effort in futility, to claim that if your client's account was overdrawn upon a request for an overdrawing, for instance, an overdrawn check that your client did to the bank, it will be an effort in futility to claim in future that the bank is not entitled to recover that overdrawn amount because there was no contractual stipulation on the terms of that overdrawing. Usually, the banks will automatically, the moment that your client overdraws their account, there will be an entitlement on the part of the bank to recover that extent of overdrawing based on the usual terms. And when you talk of the usual terms, we are talking of the terms as to interest and other charges by the bank, which we will also see shortly. So, but the basic rule is that it will be expected that before a customer's account is overdrawn, there is an agreement between the particular customer and the bank on the limit of the overdraft facility. Now, the pricing of this overdraft facility will be one of the terms that generally will be agreed upon. And like we've said, in the absence of such an agreement, then the usual bank usage and practices will apply, right? At any given time, what will be the applicable interest rate for that extent of facility based on this particular customer to cover for the risk that the bank is taking by honoring that overdrawing. Now, much as yes, the bank may be entitled to impose interest on an overdraft facility, it doesn't mean that there is a very unfettered discretion on the part of the bank to impose this interest. There are both common law and statutory constraints on the power of the bank, even where there is no agreement, as to those terms, on the extent to which the bank can impose the interest and also the charges against a bank customer. If there is an agreement, the typical provision in some of those agreements, because of at times the power imbalance between the bank customer and the bank, you will find a lot of discretion given to the bank, even within the overdraft facility agreement itself, that the bank reserves the discretion to review the interest rate for the facility. But that does not mean that that discretion is unfettered, both under common law and under the Banking Act itself. For instance, if you are entitled as a lawyer, if you feel that the interest charged by a bank is unreasonable, right, or amounts to some dishonest imposition, courts have held that there are very subjective, of course, grounds upon which the bank's discretion to review interest rates can be challenged. At common law, forget even about statute first, at common law, right? And the terms that the courts have over time used is this interest capricious? Is it unreasonable? Is it dishonest imposition? Is it oppressive? Right? Very subjective terms. But if you can persuade court that yes, yeah, you the particular interest meets these particular standards, yeah, of being oppressive, etc., then the court will set aside that particular interest charge, and the bank will not be able to recover the interest and the charges that it imposes. At by at statute, there is a rule called the Duplam rule, under Section 44A of the Banking Act, that which is an additional constraint on the bank on the interest that it can charge. That interest charge should not exceed the principal amount, right? So, yes, an overdraft facility agreement may grant discretion to the bank to impose interest or to vary interest charge, but that discretion, the bottom line is that is not unfettered, right? Now, related to interest charge, in an overdraft facility, what I always call penalty fees. There are instances where a bank accommodates a bank customer in circumstances when there is no obligation to do so. And I'll repeat the former example which I gave, where a bank customer is not has no underlying facility agreement with a bank to overdraw their account, and then the bank proceeds to honor a request to overdraw the account, either because a check is written in excess of the amount standing with the credit of the customer, or for whatever reason, without an underlying agreement, the bank accepts to overdraw the customer's account. Now, if that happens, there are some banks that have come up with additional charges again as a customer. Typically, the bank will be, like I said, expected to grant this facility on their usual terms and practice. And the usual terms and practice are what is the applicable interest and what are always the standard charges by the bank, if at all this particular overdraft facility is being given to the customer, right? In terms of the bank commission or legal fees that the bank would charge. Those are accepted, those are understandable. But if the bank goes over and above some of those usual charges and the ordinary interest to impose a charge as a further consideration for accommodating the customer in circumstances when they are not obligated to accommodate the customer, that amounts to a penalty. And penalty comes in various forms. Some have called them honor fees for honoring the payment, or dishonor fees for the customer purporting to write a check when they know that they don't have sufficient funds in the account, or late payment fees. Over and above the interest, what we are saying here is over and above the interest charge and the usual charges of the bank, if there is a charge that is imposed by a bank for the sole reason that the bank is accommodating the customer in circumstances when they are not obligated to accommodate the customer, then a penalty arises. And the validity of penalty has been litigated. Some courts are of the view, the dominant view is that they are not enforceable. But there are some courts, like in Kenya, I think there are varied decisions of the High Court. One by Justice Ibrahim that argues that penalties are part of the trade usage in the banking industry, and so they can be enforced. There's a different viewpoint by, I think, Justice Odonga and Justice Wasame, that unless these penalties are disclosed, in the overdraft facility agreement, then their effect is to clog the equity of redemption by the bank customer. And so they should not be recovered. They cannot be recovered if they are not stipulated within the agreement itself. Why do they clog the equity? By the equity of redemption is the right to recover, that asset used as security upon payment of the full value of the loan and interest. So why do they clog? Because according to the judges, the penalty is an additional burden on the part of the customer. And so unless the customer had a foresight of imposition of this particular charge, then the bank will not be entitled to recover it, right? Now, they've gone further to even link it with the consumer protection right under Article 46 of the Constitution and say, look, by allowing the bank to impose its penalties on a loan, on an overdraft facility, what the bank is essentially doing is that it's depriving the bank customer as a consumer of the benefit of full information of this service that the bank is actually extending to the bank customer. And so if the bank did not stipulate in the overdraft facility agreement that it would at some point, if certain circumstances arise, impose a penalty, they will not be entitled to recover those penalty charges. Gladly, there is a Court of Appeal decision that I think has settled this point in Kenya, that these trade usages and customs, they all differ to the provisions of a statute, so that what the court should look at when determining the validity of a penalty charge is whether or not it was authorized under Section 44 of the Banking Act by the Minister for Finance. And so to the extent that the particular penalty imposed by a bank is not within the raft of the charges by a bank, it's a charge by a bank, it's not within that raft of charges by a bank that is authorized under that section of the Banking Act, then it is not enforceable. And so it's my view that in Kenya, the legal standpoint is that yes, penalty charges, they can be imposed by a bank, but only to the extent that they are authorized under Section 44 of the Banking Act. Otherwise, they will be unenforceable. And if faced with such kind of a case, I think where to look at is within the authorized charges, whether that is part of the authorized charges under Section 44 of the Banking Act. Right? Now, how do we appropriate payments of under an overdraft facility? Ideally, an overdraft facility account is like a running account statement. Like we said, this is a facility that is intended to bridge that liquidity mismatch between when the company actually generates cash, generates asset, and when they are paid for it. So it is expected that when these assets are paid for, there will be a credit done by the company, a deposit done by the company in their overdraft facility account, right? So there will be a credit in the account, and of course in the intervening period before they get paid, they will be making drawings, of course subject to the limit that is imposed under the overdraft facility agreement. So if the company deposits money to the overdraft facility account, there is a rule called the rule in Clayton's case, which says that this particular deposit that the company has made be used to satisfy the drawing that the company made first in time, right? So that is an additional protection to the bank customer against interest charges. We all know that the more that a debt remains unpaid, the higher the interest charge it actually attracts. So if a credit is done by the company, it is not open for the bank to use it to clear a latest debt, a latest drawing by the company. It is supposed to be used to clear the earlier debt. All right. So the rule in Clayton's essentially says that a credit in an overdraft facility account is supposed to clear the drawing that was made first in time. Now, on repayment of overdrafts, overdraft facilities are always paid on demand, and those are technical. That's a technical term. Payment is to be done on demand, meaning that when the bank issues a notice to the bank customer that is no longer willing to grant the overdraft facility, the bank customer is under obligation to repay the overdraft facility immediately. And what does immediately really mean? Of course, people are not expected to be working with money. They are not expected to have money under their mattresses. Of course, some people do, but ideally, typically people don't. So immediately means quickly. It doesn't mean that the bank customer is supposed to apply for further financing. All that it means is that the bank customer be given some reasonable time so that they can put together the mechanics for repayment. And these mechanics means gathering of perhaps funds that the bank customer has in various accounts, if it is a group, perhaps in its group accounts, so that they pay back the facility within a reasonable time. And it is for this reason that overdraft facilities are never used for long-term investment, because the moment that the bank demands the repayment, it is expected that it be done immediately. Otherwise, the bank will be entitled to start enforcement proceedings. If, for instance, you had used a security, they will start to the process of now enforcing the debt against the security that you had used. Now, the rationale for this on-demand repayment is actually linked by the very nature of the facility itself. Remember, as a bank customer, the moment that you enter into an agreement with a bank for an overdraft facility, the bank owes you an obligation to honor your demand for the facility. Immediately, you apply for it. And it is in the same vein that the bank also is entitled to recover their loan from you immediately that they demand for repayment from you, right? So it's kind of a fair balance of transactions between the bank customer and the bank. Now, lastly, we'll talk about how insolvency is relevant to overdraft facilities. Remember, we said that overdraft facilities typically constitute debits and credits on a bank customer account. And as and when some of these credits come in, they will offset debit entries, all right? But there will always be a constraint on the bank if the particular bank customer goes into insolvency. Insolvency is always commenced, court-ordered. There are other forms of voluntary forms of insolvency, but a court-ordered insolvency commences the moment that a petition is filed in court, right? Now, under Section 429 of the Insolvency Act, there is a constraint on disposition of the company's assets the moment that insolvency proceedings are commenced. That is the moment that petition is presented. Actually, there is an invalidation of disposition of company assets upon presentation of a petition to wind up a company, right? So what an overdraft facility does, we said, and I want to reiterate this just for clarity. If there are credits that a bank customer does on their account, and the bank uses that credit to offset a facility, the overdraft facility, what the bank is technically doing is that it is disposing the funds of the company towards repayment of the facility. Remember, the bank, by granting the overdraft facility, is a creditor to the company, and it could be one among very many other creditors. Now, what Section 429 of the Insolvency Act does is to try and bring a balance, amongst creditors in recovery of their debt from the same company. So if the bank that has access to some of these credits by the company into the overdraft facility account, debits or uses these credits to pay for the drawings by the company at a time when already there is an insolvency proceeding commenced against a company, then the bank will be preferring itself, which is outlawed under the Insolvency Act, right? So what the law requires is that for the bank then to proceed to pay the debit entries using these credits, they must get leave of court through what is called a validation order. And if they don't do that, the liquidator is entitled under the Insolvency Act to upset, to reverse some of these debits that the bank will have done from the credit deposits by the company after the commencement of the insolvency proceedings. So if acting for the bank, whenever the insolvency proceedings are commenced, they're always published. So it will be deemed that the bank knows about the commencement of the insolvency proceedings against the bank customer. So if you are acting for the bank, it's always important that you advise them that for either they can apply to court for a validation order and justify why they should pay out the outstanding debits from these credits by the company in the overdraft facility account. Of course, this only applies if there is an existing overdrawing on the account. If the account is in debit, as at the time when the insolvency proceedings are commenced. If the account is in credit, meaning there is no overdraft facility, and the bank pays out third parties on instruction by the company upon commencement of the insolvency proceedings, then those proceedings, those payments cannot be upset, cannot be reversed by the court as against the bank. They can be reversed, yes, but as against the third parties that the bank actually pays. Why? Because courts have held that in that circumstance, if the account was in credit as at the time of the commencement of the insolvency proceedings, what the bank will be doing is honoring instruction, from a principal. The bank is just a paying agent, and in any event is not preferring itself. It's not the recipient of the payments. The payments are actually in favor of third party payees, who may be other creditors of the company. So yes, the transactions can be upset, but not to the detriment of the bank. They will be upset to the detriment of these third party payees. Thank you very much for listening to me. Again, my name is Matthew Zokoth, and this is Corporate Law Tunnel, episode 8. In this episode, I have tried to define overdraft facility as part of a broader category of loan finance, and identify other forms of loan finance. I've identified when it can be valid and how it is priced. I've identified the priority of payments in an overdraft facility. I've also identified what immediate on-demand payment in an overdraft facility means, and lastly, the relevance of insolvency proceedings to an overdraft facility. Thank you very much for listening to me. I kindly continue to urge you to subscribe to my channel if you find these recordings helpful. Thank you very much, and bye-bye for now.